Hello and welcome to this edition of Rights of a Free People, a production of the Rhode Island affiliate of the American Civil Liberties Union. My name is Newell Warde. I'm the Executive Director of the Rhode Island Medical Society and a proud member of the ACLU since 1983. I think a lot of us can remember exactly when and why we joined the ACLU, as I did 35 years ago. But that's a story for another day. We're here to talk about medical privacy, medical confidentiality. That's the right of every patient to expect and demand that their personal medical information shall be kept confidential. Since the 5th century BC, it has been universally recognized that the therapeutic relationship, the relationship between the caregiver and the patient, requires confidentiality. And so we see, since from the time of the very first Hippocratic Oath, down to the present day, every doctor, every dentist, psychiatrist, psychologist, podiatrist, every nurse, every physician assistant, every healthcare professional takes an oath. When they enter their profession, they take a solemn oath. And I think all of these oaths are derived ultimately from the Hippocratic Oath of 2,500 years ago. But they all have certain elements in common, and one thing they all have in common is the obligation and the promise, the commitment to preserving, protecting the patient's confidentiality. Why is this so important? Well, it's important to begin with as a matter of affirming and respecting the patient's autonomy and individuality, but there's a very practical aspect to it too. The patient has to feel comfortable sharing very personal, very intimate things with the caregiver. Otherwise, the caregiver, if he doesn't know all the places it hurts, he may not be able to help the patient. And breaching confidentiality can definitely do great harm to a patient. It can ruin their reputation. It can disturb their relationship, their personal relationships with others. They can make them unemployable, uninsurable. So there are lots of reasons why confidentiality of patient information, medical privacy is so important, not just here, but everywhere around the world. And of course, as we go from ancient Greece to into the digital age, where all of a sudden we can move great gobs of information across continents and around the world in seconds, things get even more complicated. That's why we have HIPAA, for example, the Health Information Portability and Accountability Act of 1996. It's amazing to think that HIPAA has been with us, will have been with us for, what does that make it, 22 years this year. And what does HIPAA do? HIPAA defines the responsibilities, spells out the responsibilities for all the various actors in the healthcare system to protect patients' personal medical information. Well, we here in Rhode Island, of course, we've had our own battles over the years over medical privacy, and I'm proud to say that the Rhode Island Medical Society and the American Civil Liberties Union of Rhode Island have been comrades in arms for decades in fighting for patients' rights to privacy. And every year brings new challenges, very recent years being no exception. So here to talk about all this with me, we're very happy to have Clingham, who is the mental health advocate for the state of Rhode Island. Welcome, Meg. Thank you for being here. And Mulready, who is the supervising attorney for the Rhode Island Disability Law Center and a member of the board of directors of the Rhode Island ACLU. Thank you very much for being here. And we have attorney Pat Quinlan, who's a versatile veteran of many State House battles, and a very able and articulate representative of a variety of healthcare professional groups. Let's talk about opioids. Everyone else is talking about it. We may as well too. I think it's fair to say that every public emergency brings with it potential threats to our civil liberties, and the opioid epidemic is certainly no exception. And for years now, our entire country has been in the grip of this really tragic opioid epidemic. And one of the tools that Rhode Island, and I think every other state, has put into place to combat this epidemic is the Prescription Drug Monitoring Program, the PDMP. The Prescription Drug Monitoring Program is an important online tool to help doctors and other prescribers prescribe responsibly, and to help them identify, seek out, screen out drug-seeking patients, and before prescribing an opioid for a patient, the prescriber is expected, required actually, to go online and check the prescription history of that patient. Now, law enforcement can also access the PDMP. Originally, they had to get a warrant, which means they had to provide a judge with a specific rationale for poking into the PDMP to see a patient's consumption habits or to check a physician's prescribing habits. But all that changed last summer. And Pat, I think, let me ask you, I think well, everybody knows a lot about this. Let me ask you first, you lived through all this at the State House. And well, can you pick up the story? Sure. and comment on the ramifications of where we are today with the PDMP?
Thank you, Newell. Yes, it actually, the problem began in 2016. The law as enacted required that if anyone wanted to obtain information from the PDMP, law enforcement or anyone else, they would have to obtain a warrant, which is the process of going before a judge, essentially telling them whether you have that you have probable cause to believe a crime has been committed. So that warrant protection at that point was in the PDMP of 14 states. And in 2016, initially, the Attorney General's office came in with a proposed amendment that would allow any law enforcement employee to access the PDMP. The medical community stood up and fought against this, and the bill died in 2016. During the 2017 session, they came back with a new request from the Attorney General's office, and it was much more narrowly tailored. It essentially would allow a certified drug diversion officer. This is someone who takes a course, usually put on, we suspect, by the Attorney General's office. It's not defined in the law. That trains them in how to investigate diversion of drugs, either from a doctor's office or through using a prescription scheme or something else. So the Attorney General's office put that bill in, and amazingly, their rationale was that they wanted to address pill mills in Rhode Island.
Right.
Now, pill mills are one of the big causes of the opioid expansion, the opioid epidemic expansion back in Appalachia and throughout the country, where doctors are writing tens of thousands of prescriptions in these small towns for opioids. So we did not think that argument was valid. We argued essentially that what is the problem with getting a search warrant? I mean, it's done every day. As a former prosecutor, I've gone through that process. If you have information that will lead you to believe and have reason to believe a crime has been committed, you go before a judge, independent judicial officer, and that judge makes the decision on whether or not you're going to be entitled to that information. So they were able to pass a law over the objection of the entire medical community, the ACLU, a number of legislators have brought this issue up, and allow these drug diversion investigators to go into people's private prescription records and sort through them and look for information on which they might want to prosecute a case.
You can help me with this, and at some point I think I got confused. Somebody said to me, well, you know, it really isn't that bad. Because it's not local law enforcement who would have access to these things and be poking around in people's medicine cabinets, in effect, but it would be only federal agents who would be looking for big guys, for kingpins, for, you know, and therefore it seemed less onerous and less threatening. Where did I get confused with that?
Well, that was in the discussions. That was how it was posed to the legislators. So it wasn't just, as it turns out, the law was written to allow employees of the Attorney General's office, state police, FBI, DEA, USDA, all to have this access to these records. So although they took out the local police departments, they kept in the Attorney General's office, and I think they limited it to their patient abuse unit and their Medicaid fraud unit. Again, the premise was that they were going to crack down on pill mills. So the federal government under HIPAA still uses warrants, because HIPAA does require a warrant or a subpoena. But at this point now, for the state of Rhode Island prescription database, there is no warrant requirement. That was eliminated. Mm-hmm. So they need to tell the health department that they have an investigative number. They have to give an investigative number to the health department, and once they have done that, then they are given access. And it's unclear in the law whether or not the access is by a Department of Health employee giving specific information, or whether they're given access into the database and gather it themselves. The law is not specific on that.
I remember, now that you mention it, the reference to the pill mills. Is there any evidence that we've had pill mills in Rhode Island?
There's not that I'm aware of. I know that the problem, if you look at the opioid deaths, which is in Rhode Island, which are giving rise to this issue, the vast majority of deaths, more than 2/3, are either heroin or fentanyl. Yes. And this is not coming out of prescriptions. Right. This is coming out of manufactured product or shipped product into the state. So I don't know that, I mean, at the end of the day, that's not going to ever pop up in the PDMP in any of it. Someone selling fentanyl, it's a street drug. Right. Someone selling heroin, it's a street drug. Right. So the crisis in most states, particularly in New England, is predominantly heroin and fentanyl overdoses. Yes,
and you know, Ann and Meg, maybe you want to chime in here. These you know, the certified drug diversion officers, I'd forgotten about those. And there is specific training for these. I mean, who are these people?
Well, we don't know who they are, if I might, but I know of no training, specific training. It's not in the law.
I'm not aware of any either. And I don't think that the law provides for specific standards for their training. So it can be created as we go, so to speak.
I mean, the definition in the statute, a certified drug law enforcement drug diversion investigator means a certified law enforcement officer assigned by their qualified law enforcement agency to investigate prescription drug diversion. So it's whether it's a federal agency or a state agency, it just does not specifically mention local.
If you're just joining us, we're talking about patients' rights to confidentiality of their personal medical information. I'm Newell Warde. I'm the Executive Director of the Rhode Island Medical Society. And with me here are our panelists, Meg Clingham, Rhode Island mental health advocate, and Mulready, supervising attorney for the Rhode Island Disability Law Center, and Pat Quinlan, longtime trusted resource and advisor on healthcare issues at the State House. Maybe we've turned to current care, there's something very interesting and to me very strange that's been proposed with regard to current care. First of all, what is current care? I mean, I would describe it as our health information exchange system in Rhode Island established, I don't know, maybe 10, 11 years ago. And the idea, I think, was, a wonderful one to realize the great promise of electronic medical records, that we could move information so that, if you live in Burrillville, but you have to have your appendix out on an emergency basis in Westerly, why the doctors in Westerly can call up and see what you're allergic to and what drugs you're on and so on. But I remember, and I don't want to, you know more about this than I do, I remember we had a great community discussion and a great collaboration years ago when we were trying to decide how the current care would work, how the health information exchange would work. And the big, great question was, would it be an opt-in system where patients would have to say, yes, affirmatively, I want to be a part of this, I want to take advantage of this, or would everybody be in and it would be up to the patient to say, no, I don't want to be a part of this, I want to opt out. At the time we said, and I was really proud of this, I thought this was really courageous on our part, to say, if Rhode Islanders are going to trust this, it's got to be opt-in. And we've done that, and we've signed up about half the population, and 500,000 Rhode Islanders, I think, about are now in current care. I'm in there. But a funny thing happened on the way to the State House or whatever. Can you pick up what is going on with current care?
Yes, it's not on the way to the State House,
Yes,
actually.
I'm
It's
sorry.
really on the way to proposing new regulations. The Department of Health is proposing to change from an opt-in system to an opt-out system. So I know the ACLU has taken a position on that and feels that that is certainly contrary to the spirit that you mentioned of the stakeholders who were involved in the long discussions that were had about this, but also contrary to the letter of the law,
Yes.
which requires consent, we think, in order for a patient's records to be accessed within the database. And so I'm not sure that health agrees with that legal interpretation, whether they think they need additional statutory authority or they think the current statute gives them that authority. I think they would say that they are not really, patients don't need to consent because all we're doing is storing their records. We're not really accessing them. So within the statute itself, there are 4 exceptions to when a patient's records that are within the HIE can be accessed without their consent. And so they can be accessed in an emergency situation when a healthcare provider needs vital information to treat someone in an emergency. The Department of Health itself can access a patient's records if it's consistent with their public health authority and the various statutes they have to monitor public health issues and other health conditions. It can also be accessed by health plans and health insurers if they're doing care management, and it can be accessed by the health information exchange itself for administrative and quality control purposes. So it's a little misleading to say that we would just be storing records when there are these 4 exceptions under which they can already be accessed without a patient's consent. And I think we also feel that the statute pretty strongly, even though it doesn't use the term opt-in or opt-out, that it pretty strongly talks about consent for records to be released to the HIE and consent being necessary from patients as well as providers. So,
can you refresh my memory? Where are we in terms of the, how capacious is current care? What kinds of information is in there now, is being shared in there? Are you familiar with that?
So I think just about all information goes in, and that was when you mentioned the stakeholder meetings, the very sort of robust and discussions that went on in the state
Yes.
about setting this up, there was a lot of discussion about segregating specific information. So, for instance, people in the disability community were very concerned about mental health records or HIV or other sensitive data. Could we segregate those? And the great compromise was, no, we're not going to allow any segregation of data, even though there are systems, other places that do allow segregation. That was a possibility. But the one great compromise was that we won't allow segregation of specific data, but people are going to consent to their data. So it's not going to be a problem because people are going to knowingly participate. And the remedy, if you have concerns about protecting sensitive information, the remedy is to just not participate. So now, with the proposed new regulations, the department is taking away that one final individual right that somebody had to say, okay, well, no, that's not for me, I'm still worried. And you know, people worry about databases in general, but particularly medical record privacy databases, both from a perspective of what can be gained legally as well as illegally. And we read about breaches every day, right, insecurity that happens. Even the best protected systems have failures at times.
Yeah, you can probably comment on this. I was under the impression that there were, in a sense, at least if the data wasn't actually segregated, there were two processes for giving consent, and that somehow for substance abuse and mental health issues, there was a separate special consent. And that's federally protected, actually, right? Where are we with current care? What, is that?
Well, there are heightened levels of confidentiality for substance abuse disorders. Also, the Rhode Island mental health law has specific, in addition to the Rhode Island confidentiality laws, the mental health law has a specific provision requiring heightened confidentiality of mental health records.
Okay.
The concern, obviously, is as the person who, it's my directive to protect my clients' civil rights as people living with mental illness and substance abuse disorders, is that trust in their doctor is essential. And if people are afraid that their information will be shared, they're not going to be able to be fully forthcoming. They won't be able to get the treatment that they need, and that just breaks down the physician-patient relationship to a point that I think is very damaging and stigmatizing.
We'll just have to see how this plays out, right? Is there a timetable?
No, I think there's an open question about whether the Department of Health will proceed with promulgating this rule, or whether it will decide that the better route is to seek legislative change if that's what it wants to do. So we don't know yet.
Well, here again, the Rhode Island Medical Society and the ACLU are very much on the same page. There's one other database issue out there that has become controversial and worrisome, and that has to do with the all-payer claims database that we have built or are building. What are the issues that are emerging with that? You're more familiar with that than I am, I think.
There is another proposed rule that would allow the Department of Health to treat state agency requests for data from that database differently than requests from private entities. So there is currently, the department has a process for a review board to make a determination about if somebody's requesting data, to look at how the data is going to be used, if they will be able to somehow, it's de-identified data, but will they be able somehow to delink that data and reassociate it with an identity? And then I think the last issue they look at too is looking at its use and looking at security and privacy issues. Do they have enough security for the data that they actually are going to be looking at and utilizing? So the proposal in the rule was to exempt any state agency from that process of review. So I think that was something the ACLU felt strongly about, that there isn't a strong justification for treating state agency use differently from private entity use, and that the review in general was a good idea for protecting the health information stored in that database.
And the purpose of the all claims data, I mean, it was for scholars, for public health research, I guess. Do the plans themselves, you know, Blue Cross and United and Tufts, who must provide the claims data that goes into this, do they have access to each other's claims data in effect through it, or am I, asking the wrong crowd? Because
I'm not as familiar with that aspect of it. I know that plans can ask for data, and I don't know.
But it seems to have very little to do with patient care.
Correct.
I mean, it would seem as though this would be useful for, but it's not about patient care, and it's all de-identified, and in a way, maybe that's a good thing. I really don't know.
I think the idea of research is, to have data for research is not a bad thing. To look at longitudinal use and outcomes is not a bad thing. But I think having some safeguards in place for that apply across the board to everyone, both the state and private users, seems like a good idea. Why would we differentiate?
Well, anything else that
Pat,
did you want to add
touch
something?
on one thing? I mean, I find it, listening to the other two databases we're talking about, when you have an opt-in, on the prescription monitoring database, it's not voluntary. All the prescriber is required to enter is required to tell the patient that it will be entered into a database. The pharmacist actually enters it when they fill the prescription, but the patient has no right to opt out. That data is collected, and the patient really has no rights at that point. It's the provider's obligation to tell them it's going into the database, and there's a civil action available if they don't tell them. But that's one of the reasons I think the provider community was so outraged with this granting of access, because at least in the opt-in system, the HIE, the Health Information System, people have made that decision, and the proposed amendments aren't really protecting that if those amendments go through. But in the prescription database, all of your prescriptions go in, your dog's prescriptions go in, anything that gets filled by a pharmacist is associated with your name and birth date, so it goes into the database. So I think that again, makes it a little more egregious as to what they've done here, because the patients have had no say in the process whatsoever.
Well, we've talked about some interesting problems, some things that are going to be playing out in the coming months, and we will keep our eye on the ball. Thank you all. I want to thank our panelists, Meg and Ann and Pat, for being here, and I want to thank all you lovers of liberty out there for watching Rights of a Free People.